Good evening. Thanks for having me here. I appreciate it. Just to tell you a little bit about my background, I'm an engineer myself. I started out as a chemical engineer, and I worked in a chemical plant for about 7 years before I went to law school. And now I mostly do litigation. And because I'm an engineer, a lot of the cases I work on happen to be technical cases. So what I thought today is, I just recently tried a case where root cause analysis and engineering analysis was a really big topic in the litigation. And I thought it wasn't done very well, in my opinion. What the refinery did after the accident, it seemed to me missed a lot of things that really would have led to a much better analysis. And they were fundamental flaws, I thought, that made it easy for an attorney to really exploit what had been done to demonstrate, I don't want to say an absence of competence, because they were very competent. It was an absence of care in doing that. And it was the typical garbage in, garbage out situation that you get in what was really a very complex situation. So that's what I thought I'd speak with you a little bit about tonight. And as I go through this, feel free to ask me any questions. Stuff's still fresh in my mind, and I can tell you a little bit specifics about it since we actually tried it. There's not really any confidentiality issues related to it, and it didn't settle until the trial was basically over. So let me begin by talking about generally a root cause analysis. Like you can have, when you have an incident, a significant incident, it's likely that your in-house counsel or people involved with the company are going to anticipate litigation. If you're a lawyer, your first instinct is, what can I do to have an investigation I can shield it? And you want to shield it not because you want to hide things or because you're trying to be deceptive. The idea behind the privilege, the attorney-client privilege, is that you can have, as an attorney, really candid conversations with your client to try to understand what occurred. And the idea behind that policy is, if you can't have those conversations, then you're really not going to get to the bottom of the problem. That runs counter to what most analysis we do in the industry involve. And by that I mean, if you have an incident and it's significant, I'll give you an example. If you're offshore, BSEE regulations will come in and tell you, well, your SIMS program tells you how an investigation needs to run. It tells you in broad forms what you have to have and with whom you've got to share it. That same thing with OSHA, where you have an incident and you have the process safety management guidelines. Those types of investigations you really can't shield, and those will become discoverable. So if you have an incident, that's one of the things of concern. As you go through these investigations, every piece of paper, every witness statement, every photograph is going to get discovered by the other side. And I'll give you an example. In my case that I just tried, it involved an air cooler that failed in a refinery. And when it failed, it started a large fire that took out a whole isocracker unit. After the investigation, after the evaluation of damages, that case had 700,000 documents. We got to see all of them, right? I represented the manufacturer of the air cooler. It all came in. I got to see all the analysis of how they got to where they got. So all of that, even though you want to shield it, probably isn't going to be shielded. There was only one document that the company shielded in relation to the investigation, and that was a root cause analysis that they did specifically for the attorneys. And the problem with that was, it really didn't matter because the analysis, the fundamental analysis, I thought wasn't done correctly because there were some assumptions that were bad. So when I tell you what you typically see on any root cause analysis is you're going to have a description of the incident, and as a lawyer, what you care about is I want to know what the contributing causes and conditions are, and I want to know what the recommendations are. That's hard to shield, especially if you're doing it under BSEE regulations or OSHA regulations or DOE regulations. You're not going to shield that. So the recommendations matter. So what I would like to do is kind of walk through some of these ideas so that you think about, if I'm ever involved and I've got to do this type of analysis, or I'm one of the participants, because when you have a significant incident, the analysis isn't done by a single individual, right? You'll have a whole team that comes in with different subject matter expertise, right? In the case that I tried, where we had a refinery incident, we had process engineers who were involved, metallurgical engineers who were involved. Because there were damages, we had economists that were involved. There's quite an art to scheduling refinery production. So it involved multiple disciplines, and involved operators, because it involved procedures. So it was fairly complex as to how you go about collecting the evidence, analyzing it, and putting it together and coming up with contributing causes. So I want to tell you, what's the value of this for the typical attorney? I went the wrong way. Here we go. All right. When an accident happens, and if I'm opposing counsel, the first thing I really want is I want that root cause analysis. And I want everything that went behind it. To begin with, I'm not an expert in the technology. As a lawyer, I won't know anything. So I'm looking for that root cause analysis to educate me as an attorney as to what happened. It tells me what kind of subject matter experts do I need to start looking at to evaluate. And when I'm looking at the report, I'm seeing it as my roadmap. It's either a roadmap, it's got the conclusions I like, it's my roadmap, and I'm going to find a way to bolster it, and I'm going to try to find a way to make it really something that I can sell as a very good piece of work. If in this case, where I was representing the maker of the air cooler, the attack was on the air cooler. So for me, it was a roadmap as to how they would try to demonstrate the liability of my client in the lawsuit. So it became my roadmap, but not in the sense of how am I going to get there, is what obstacles do I have to raise as we go down the litigation process, right? So that's how that becomes to me. It's the other side's roadmap, so when it's, for me, I'm looking for roadblocks, obstacles I can create. The focus when you get to these things is you have a real focal point on the causes and conditions, right? Because to impose liability on any company, right, it's real basic, right? It's negligence, and if you went to law school, you hear, well, you got to find a duty, right? There had to be a duty of care. There had to be a break in the duty of care, and that break in the duty of care had to have caused somebody damages, and then there had to be some form of damage that I can measure. When I can prove all of those, and I'm the plaintiff, well, I'm probably going to get a recovery. So those become the additional roadblocks I'm looking at. Okay, can I attack the causation? Can I show that they come to the wrong conclusion on what caused the accident? Can I show that they got it wrong on the conditions? And when I speak about conditions, it's I think of it in the sense of non-passive situations. What were the tank levels? How were the valves aligned? Where were people standing? To me, those are conditions. As opposed to the causes, I think about affirmative actions or omissions that things people did or didn't do, which they should have done. So those are the things I'm looking for. And then I'm looking for fault and responsibility. And that root cause analysis, it has all of that, right? It has all of that, not in legalese, but in facts that somebody's put together and somebody's come together with it. And if you're doing it for your employer, your company, you have issues you've got to think about too, because it's typical that we do a root cause analysis or an engineering analysis on any failure for the purposes of taking corrective action. Right? I have rarely seen a root cause analysis. This was an exception in this case, where the company says, we didn't do anything wrong. Right? Always. So I'm always looking for that when I do this type of a case. What's the company's finding in fault? And one of the things I'd like to leave you in mind is when you're writing those kinds of reports, things to consider are, well, what's going to get discovered? That's what's the other side going to see. And then there's a second stage. The second stage is, what will the jury see, right? Because when you're litigating one of these cases, it's two thresholds, right? The very first threshold you reach is, do I get it, right? If I'm the opposing counsel, can I get it? And is it discoverable? If I can get it, then that's one stage of the process that's helpful to me because it educates me. The next process is, if it's got admissions or it's got fault finding that helps me, can I get it in front of the jury? There's nothing more powerful than to show a jury that, look, the company analyzed its own action and came to the conclusion that it's responsible, right? It's very powerful when you're trying a case and you can demonstrate that. So those are the things that I'm looking for. Especially, and I don't do personal injury, I do commercial work, so this case was all about damages for equipment and lost profits. But if you're a plaintiff's lawyer and you're doing a personal injury case, that's particularly helpful to you. You really, really care about that because that brings a lot of emotional appeal to it that the company's blaming itself.
Sorry, can I ask
Yeah.
a quick question? Why, you're saying then that companies are often, want to get to the root cause and they're open and they will assign self-blame. Why in America will companies do that?
Well,
because of trial.
well, remember and I think there's a good reason for that, right? The ultimate, if you think about what the regulatory requirements are for these analysis, the whole idea is corrective action. Mm-hmm. So a company, and I think the best approach a company can take, and this is just my personal opinion, is to come up with a good root cause analysis. Because ultimately that's what you're trying to do. You're trying to make your systems more robust, and that's why you do it. And that's the whole idea behind it. I'm not as familiar with the BSEE regulations as I am with OSHA. Since I'm a chemical engineer, I was around them in a practical sense. So I always viewed them as valuable because the whole idea is to have lessons learned and incorporate them to prevent them. As a company, I think what you care about is, you're going to have to do that, right? Somebody's going to come behind you and investigate it anyway if there's litigation. And if it's a big incident, they'll have really good experts and really good people looking at it. But there's another thing. There's also the future, right? Do you want to be in a situation as a company where you had an incident and you didn't really do a very good investigation and you have it again, right? You don't really want to be in that position either because the subsequent incident will be worse than the first one in the sense of liability because the argument is you didn't learn your lessons from the first one. All right? So that's why you have to do them, I think. And that's why I'm not a fan of lawyers that try to get in the middle of a root cause analysis and push it in a certain direction. I just don't think that's doing anybody any service. You do want a good, competent root cause analysis, and there's room for attorney-client privilege and communications to get the right outcome. But I don't think you ought to be pushing it as an attorney one way or another. But that's why I think you've got to do them, and that's why they're accessible to the workforce. Lessons learned, and to prevent recurrence. And I'll talk a little bit about the conclusions as we go through this, and how you can reach steps and rationale you can go through to make sure what you're doing isn't really harmful. It's really just honest and helpful both ways in case you're in litigation and in relation to corrective action. Now, the first thing when you get involved in one of these, when you get involved in these, the first step is to collect the evidence, right? And I think it's just a fundamental. You want to collect all the evidence, and you want to have it in front of you, and you want to analyze it before you start reaching conclusions. The worst situations for an attorney, if he's defending the company or somebody like an operator or someone who's had an accident, is conclusions and opinions are put on paper before the evidence is collected. Then you collect the evidence, then you start having to revise poorly thought through conclusions, poorly thought through analysis because you jump to some conclusion on some piece of evidence that you thought was correct and you find it isn't. So the important thing is to be methodical and not to rush it. And there's always there's always kind of an urgency to it, especially if a unit is down or a piece of equipment that's really important is down. There's a lot of pressure to, let's get it back online, let's get it back on stream. And there's that economic incentive, but at the same time, if you don't have the information you need, you're not going to have a very good analysis as you go through it. So what you care about these are just generally the kinds of, the type of evidence, it's what you would expect you'd want. You need to think about the people. Who are the witnesses, all right? And the witnesses don't really mean just the people who happen to be around the accident site. I'll give you an example. In my case, I thought one of the flaws in the root cause analysis was they limited it to a very narrow window. You have a piece of equipment that fails. The determination is the equipment is flawed, and there's no consideration is, did we use the equipment the way it was designed? Nobody went back to look at the process design package that was associated with the equipment. It's a big package, right? It's a nice cracker, so you've got a big package that tells you about conditions, operations. Nobody goes back to look at that. They've got warnings in there that tell you how you should and shouldn't operate the equipment. All they're looking at is, well, I ran it this way for 5 years without an accident, and wow, now look what happened. And in my case, they were running it, yeah, but I happen to have an odd startup on the coldest day when there was water going through the air cooler when there shouldn't have been, and then you introduce hot oil into it and you have a problem. You ought to look a little deeper, and I'll show you some slides that will indicate that. And so when I say you're interested in people, and I think you need to be open-minded in where you go. For example, when this accident happened, nobody interviewed the process engineers who came up with the design package, so they didn't know the thought process or what the intentions were when they first introduced this piece of equipment. Nobody talked to, well, did y'all have integrity operating windows? Probably something most of you have heard about. When you set this together, things like that weren't considered. Did y'all consider balanced operations? None of that was, no one talked to those people. They talked to the operators who were on shift when the accident happened, but nobody talked to the guys that handed off the night before. Right? They looked at process data, but they looked at process data for a 2-hour window that preceded the accident. They didn't look at the entire day before. And I can understand that, right? Because you go into one of these refineries and you look at the DCS data, the process data, and it is a lot. It's minute-by-minute data on lots and lots of sensors. If you think you know the process, you come in with conclusions and you've got some prejudices about how it operates, and you think, I don't need to look any further than this. And that's what you got to guard against. And the issue is, with people, you're looking at memories. And memories fade quickly. It's among the most fragile evidence that you have as somebody who's trying to figure out what happened. Right? So if you don't talk to people quickly, memories fade, they're not recorded, and you lose vital information. The other thing is physical evidence. You want to preserve the physical evidence. And what is that? That can be a lot of things. In my case, I thought some physical evidence that was lost were the fluids that were flowing through the air cooler. Because you have the accident, their theory is a form of corrosion. They don't really sample on a regular basis, so they don't really have anything other than, well, generally we put this upstream in the distillation unit, so it goes through this transformation, so it ought to be this by the time it gets to the piece of equipment that fails. So there's just assumptions built in that don't get verified. And nobody thinks, well, let's take samples of the material that's left in the failed equipment. And that perishes, right? Because when you come in, you've got to clean everything out, make it safe to do your demolition, and that's the type of physical evidence that's lost. So you have to think about what's the evidence that is going to get lost, because you ultimately have to clean the place up. Electronic evidence is really important. Like I said, the DCS systems and data acquisition systems, they average. If you let it sit too long, you may have minute-by-minute data, but your historian starts to turn it into hour-by-hour data, and if you wait too long, it turns it into day-by-day data, and you've lost really critical evidence. So you want to make sure you take the appropriate snapshot in time, the finest window finest increments you can. In this case, as we went through, things that weren't apparent in hour-by-hour data were apparent in minute-by-minute data when we looked at it. And it really leads to different conclusions. And then you think about positions, and positions to me means where were individuals and where were pieces of equipment located or transitory, how were valves aligned. All those kinds of things need to be recorded, and often they are in the form of operating valves, and you want to find those and get those. In my case, those were lost. Those were lost in the hurry of combating the fire and the hurry of trying to get the unit safe. Critical evidence got lost. It may have been there, but nobody thought to look for it until well after the incident happened. And days of data were lost in terms of handwritten logs that could have been very helpful in understanding what happened. And that's the type of paper I'm thinking. Now, often when you have equipment failure, you think about the kind of physical testing you've got to have. I think about this, and a lot of that is destructive testing. This needs a lot of thought. It needs thought because in the early stages of an investigation, you don't necessarily know who are going to be the parties that will be held responsible. In my case, there was an early belief that the air cooler was defective, so that we finally did notify my client, and my client had people present. But I've been involved in other cases where there's not really a good idea of what happened, and people embark on destructive testing, data's destroyed, and then all of a sudden they say, well, you know what, it was a bad valve, let's bring the manufacturer in as a defendant. But the valve's been taken apart, nobody got the manufacturer's consent, there was no protocol that was shared with them. And what happens? Well, you gotta think about, if you're going to do destructive testing, or you think it's necessary for you to advance your root cause analysis or your engineering analysis in relation to an accident, you really need to have an attorney involved, be it a company attorney or an outside attorney, because different jurisdictions have different rules for when you can have destructive testing. But it's pretty uniform. You can't have destructive testing without a court order or without an agreement of the parties that will ultimately be involved in a kind of litigation or arbitration or any type of dispute subsequent to that testing. So you need to know, and typically what that means is you have to have a good sense as to who the potential parties are. You have to have a good sense for what the protocol is, and if there's no lawsuit filed, you better get a written agreement to show consent, or then you'll face a claim that you destroyed evidence. And destroyed evidence, I don't do criminal work, I only do civil work, but destroying evidence in the context of perhaps serious regulatory violations can have implications related to the criminal statutes that, you know, well beyond me, but in the civil case, it can affect the outcome. Because you can get a court that sees there's been destruction of evidence, and they'll decide, well, there's got to be a remedy for that. And the remedy is typically a form of an evidentiary penalty. So let's say I took my air cooler, and my theory is that I had a defective well, I tear it up. Well, the remedy might be that I can't put on any evidence that I discovered as a result of my destructive testing. Right? It might have been very helpful to me, right? But because I didn't get the other side's consent plan and I didn't get a court order, all of a sudden I've got a smoking gun, but I can't offer it. I'm left with just vague arguments that I got a bad well. So that's the kind of penalty that can be outcome determinative that you can have if you don't take the potential penalties that a court can impose into account when you engage in destructive testing. The other thing that you often have is when you have destructive testing, you typically, everybody wants to be present, right? And everybody wants their experts there. Everybody wants to have input into the protocol. And if you don't allow people that opportunity, that's another, you end up, you may have the greatest evidence, but you end up with a lot of, well, but for them going forward, I would have added this, this, and this, and it would show me this outcome. and it would have completely changed the whole character of what I had. So destructive testing is something that you shouldn't approach without involving counsel and really thinking about what the consequences might be.
Benjamin,
Yeah.
so if it's, can you use fairly intense, non-destructive testing, where like X-rays and sampling, do you still need agreement?
No, I don't think you do for that. As long as you're not altering the ability of the evidence that you have, there's no problem with that, right? So you're going to do ultrasound examinations, or you're going to do X-ray examinations, things that do not change the piece of equipment or the sample, you don't need agreement. Ultimately, it is discoverable because you cannot hide facts in a litigation. So if you do that kind of testing, it's not what you wanted, it's still discoverable.
But it's better to try and agree it.
You have to turn it over, but there's no penalty for having done it, right? If you get good results, you're going to be able to use them, most likely, unless there was a flaw in the way it was carried out. Then you get not into the conduct and making the decision to do the analysis. Then the issue is, were the tests done the correct way? And can you count and rely upon the results that you got from the tests?
What about dismantling it? Which is not destructive.
Yeah, dismantling it, I would say it depends on the complexity of the equipment, but if you can dismantle it, and I would video it and photograph it extensively, and I would not discard any components, including gaskets and bolts. Yeah, I think you're fine with that, but you have to demonstrate what you're doing. Right?
What happens if you have an OEM supply you the cooler, for instance, and is there no statute of limitation where you can go back to the manufacturer and say, hey, this is your equipment, why did it fail, or whatever? So, because you keep mentioning the cooler.
Right.
So, the manufacturer itself, are they still responsible for failure, say after 10 years or 20 years?
No, that depends on the law of your state, right? In most states, it depends on what the claim is. If it's a contract claim or a warranty claim, typically it's 4 years after you learn of the flaw. And there's things that modify it. Okay, so I sell you a piece of equipment. Okay, and when I sell you the piece of equipment, I represent to you through a limited warranty that this equipment has, I'll warrant the mechanical integrity of this piece of equipment for 5 years. Okay, nothing happens in those 5 years. All right, you really have 9 years to bring your claim, because what happens is if the cooler or the piece of equipment fails because of defect on year 4, day 364, now your claim's accrued, right? Now you know you have a claim, and because it's a contract claim in Texas, other states have different limitations periods. You've got 4 years, right? So if the manufacturer's around and you're within limitations, you probably want to advise them that you think you're going to sue them, and you're going to go down the road of destructive testing. Right? In other cases, if it's what's called a tort, the limitations period is 2 years, and that's typically measured from the day the accident happens. Right? That's typically what you have in terms of personal injury claims. Something happens, the personal injury claims a tort, and just in general, torts are things that are not governed by contract. Right? And contract is anything we've got an agreement. So those are the two branches, broadly speaking, of the law. You've got the tort claims and you've got the contract claims, and they have different limitations periods. So if you don't have a warranty claim, you don't have a contract claim, that doesn't mean you don't necessarily have a tort claim as a buyer. You might have, but you might not. There's a lot of hurdles depending on what state you're in. So that's kind of what I would say is, if it's within the limitations period and you think you're going to bring a manufacturer in as a defendant, or you're going to seek remedies against them, you need to let them know they're going to do any kind of destructive testing, just because you don't want rulings that are going to hurt your case. So that's the answer to that. All right, now, when you're collecting the facts, right, there's a lot involved in collecting the facts. I don't know how every organization, not every, but lots of organizations have procedures for root cause analysis. Right? Some do, some don't, but the larger companies tend to. They have lots of procedures to guide people. They have templates and forms. You should be aware whether, if you're called upon to do a root cause analysis, you should inform yourself that you have company guidelines about how you're going to carry it out, and you should inform yourselves as to whether you have templates that you need to use. Okay? And sometimes these templates are there so that they have disclaimers. The idea that hopefully it gives an attorney some argument to try to keep it out of the jury's view, or to try to argue to keep it from being produced and discovered. But regardless of how you do it, along the line you're going to be recording your information and recording your evidence. I think these things really need to be conducted at least in two broad phases. And that's the fact collection phase, and then you do the analysis as part of the fact collection phase to come up with the causes. But you really ought to try to keep the remedial measures, the corrective actions, separate. And I'll speak to it a little bit more, but you can never hide facts. Right? The facts are never covered by privilege. So it makes it easier to fight about turning over the part of the report that is corrective action. Right? Because there's rules in law that say the jury shouldn't be told about subsequent remedial measures. That's the jargon in my profession, subsequent remedial measures. But what it is, it's really corrective action, right? Jury shouldn't hear about corrective action in trying to assess liability, because one of the key issues you're trying to understand is, if you look at it, you're trying to evaluate the conduct of the parties at the time the incident happened. Right? What did they know? What should they have known? What would reasonable people have done in the same similar circumstances? That's what you care about when you're trying to assess liability. If you throw in subsequent remedial measures, then you confuse the fact finder or the jury, because all of a sudden you've got a hindsight determination. And the feeling procedurally, legally is, well, once you tell them what you determined in hindsight, can they really put themselves in the position that existed before the accident? Can they really think about what would a reasonable person, with the information they had in front of them, done in this circumstances? And that determines whether the conduct is reasonable or not. And so one of the things that you don't want, certainly, is you don't want to throw all that hindsight information into the fact-finding part of the report. The fact-finding, the other side's probably going to get it, so you want to keep it very, very objective, just objective. And that's not to say that you won't see or receive opinions as you go through the process, because you will, right? You'll sit down with some people who were involved. They've got their history with the whole situation. They'll give you their opinions. They'll want to lay blame. And that's all valid information for an investigator to consider. But in documenting all of that, it's got to be pretty clear that this is not the investigator's opinion. The investigator isn't buying into all this right now. The investigator is just recording what's been shared.
And so, what I'm hearing right now is that you would have, when you would go through these, I'm just thinking that an incident happened and they get together either that day or the next day, kind of sit down and do this worksheet. So when they say something that is hindsight, I don't remember the word you used, but do you write it down on another sheet of paper?
No, I think you write it down there.
But not on the paper that's the fact-finding paper.
You can do it on the fact-finding. The way this, in practice, the way this works out is you'll meet with, if it's a large incident, you'll meet with lots of people, right?
Right.
And each one of them will be interviewed once, maybe twice, maybe more. And you'll take notes about that. All I'm saying is, when they tell you this happened for these specific reasons, you need to note it. But you, as the person who's doing the interviewing, don't have all the facts and you don't know whether that's correct. So you do not want to say, I buy into this.
Right.
At this
Write
point.
it and you scrub it based on.
And you write it and you say opinion of or conclusion of. The conclusions that you want to worry about are the team's conclusions. after all the facts are collected, you'll identify causation. You'll have, and there's a lot of definitions out there that you'll have to think about. You'll have terms thrown around like direct cause, contributing cause, root cause, that don't necessarily mean anything outside of your particular industry or company, and may have some different meaning in the context of litigation. So all I'm saying is, before you start going down the road of making causative determinations as an investigator, you need to be perceived on paper, because all that paper will be discovered, as someone who remained objective until all the information was in. That's all I'm saying.
And the remaining objective piece is to say witness A or witness putting, not just writing it down.
Right, you have to have the context. It's important to keep the context, because it's tough if you make conclusions and then you find yourself revising them to defend them, right? It almost seems like, you know, you don't want to be subject. Everybody who touches the investigation, a serious investigation, will be deposed, right? So everything you write, the other lawyer will have, he'll study it, he'll go over it with his experts, and if it's good for him, it's going to be an easy deposition for you. If it's bad for him or her, they're going to go through a lot of time and effort to find ways to attack you. They'll try to find ways to show that you prejudge, or you fail to consider other causes, or there's information you should have gotten but you didn't get. All of that will be the subject of a deposition if you're on one of these teams. And that's why I say you want to have a record that shows that you've been very methodical and you haven't reached opinions and conclusions until all the facts are right. Right. Language matters, right? You don't want to, in the fact portion, even in the conclusion portion, you don't want to use inflammatory language. Inflammatory language, that it was a disaster, that it was a catastrophic, that it was lethal, it may be obvious, right? It may be clear as day. But when I'm a lawyer and I'm taking a deposition, I like those words. I especially like that if they're coming from the defendants or the opposing side's witnesses. Especially that can show fault on their part. I really like to show that, because when I think catastrophic or I think disaster, I'm thinking, you should have known. You should have seen this coming. So you want to avoid that, because all these things, they indicate a judgment. And you really don't want to lay a foundation of judgment in your reports as they relate to root causes. You want to keep them very analytical and very factual.
Is lethal a judgment? Someone either died or they didn't.
Well, it happens, right? You had a fatality,
Yeah.
right? But sometimes you'll see something like there were, before you even know, lethal releases of chemicals. Now, you don't know if it's lethal. You may not know. Right? You don't have the objective evidence that the concentrations were in fact lethal. Things like that, you don't want to prejudge, right? You don't want to talk about negligence, deficiencies, or carelessness of your own people. Maybe it is. Maybe ultimately you come to the conclusion that somebody was careless, somebody was negligent, but wait until you've got the facts. Wait till you really know that as you go through that. The other thing I've seen is sometimes people will want to make legal conclusions. They'll say, well, look, this was a breach of a warranty, or this was a breach of this contract, when it's difficult to make those determinations early on, especially if you don't have legal training, because some of these concepts are fluid. You'd think they'd be really well defined, but they're very fact specific. So you want to take care in how you phrase these things. And again, I say that because you never know what your ultimate conclusions are going to be. You don't want to be locked into these conclusions before you have the facts, and you don't want to have fodder for a deposition or for a trial. Okay? All right, I want to talk a thing about some legal issues that matter when you're doing one of these root cause analysis. The purpose, yeah, go ahead.
Sorry, what about car dealerships? You buy a car, they tell you, oh, the warranty has just run. Meanwhile, you still have about 6 months of warranty. So you're going to lose this, or you lose that, or whatever. You don't buy extended warranty. So you're talking about legal languages. What do you do in that instance?
I think I don't think that when you're doing a root cause analysis, you're actually trying to make a determination. Typically, you're not trying to make a legal determination about whether there's been a breach of contract or whether there's been a breach of a warranty. That's typically not what you're doing when you're in one of these schemes. You're trying to identify the facts that led, or the conditions that led to the incident. Then you're trying to identify how you can prevent it. That's ultimately what you're trying to do. You're not trying to lay blame. Right? Ultimately, when you decide to lay, ultimately the blame part is usually handed off to attorneys. Right? Here are the facts. Do you think we got a case? So that's why it's not necessary or necessarily even advisable for an investigation team to get into the issues of warranty.
You mentioned like the methodologies, bow tie and Swiss cheese model, still the methods used for.
Yeah, there's lots of models, and that the Swiss cheese model is still a viable model, right?
Right.
Yeah, I mean, if you pull up any text or treatise on root cause analysis, there's maybe 6 or 7 that people apply, and that's one of them. Barrier analysis is one of them that people apply. And it's a valid model, right? And when you talk about methodology, I think when you go through, and I'm not an expert on the methodology, but if you go into the texts and the treatises, some methodologies are better for certain situations than others. And what you want to do is you want to tailor your methodology for your specific situation.
And in general, you being the attorney being the attorney, do they get involved in which methodology they use, or do they let the client pick?
I wouldn't want. I don't know. I think that depends on the attorney you happen to end up working with. My sense is you don't want to tell an expert what an expert ought to do. You're really relying on your subject matter experts to come up with the right methodology.
Right.
You want the subject matter experts to own that decision, because ultimately, this is kind of how I look at it. I'm an advocate for my client. The people who do the analysis are advocates for their opinions and their conclusions. So you need to own those. So I don't want to be telling anyone that's a subject matter expert who knows more than me what they ought to do.
Sometimes do multiple methods get used, I guess?
I think you can have multiple methods, right? Yeah. And it just depends on the circumstances. And I'm going to try to stick it to 45 minutes, so I'll speed up if I'm going too slow. But the other thing I want to talk to, the two phases, right? When you do the root cause, you've got the cause that's direct, contributing, and root, right? And there's different definitions for them. It depends on what you look at. Like if you pull up the Department of Energy's handbook or manual on accident investigation, they'll call it a contributing cause basically any cause that had any role in the incident. But that's a confusing term in the legal context, because in the legal context, a contributing cause is a but-for cause, right? It means that but for this cause, this incident doesn't happen. That's a contributing cause. So what I would say is when you start getting into using causation, it's good to define them so they aren't taken out of context. What do you mean when you use a root cause? What do you mean when you use a direct cause? There's definitions out there in the textbooks, because if you don't have it, your attorney or the attorney who's adverse to you will try to put a definition in your mouth, right, when they deal with you. So be clear on your definitions. The technical words matter, especially when there's some overlap, like in like in the litigation field, causation is such a big thing, and foreseeability is such a big thing. So think about your definitions. All right, and that's why I say think about your potential readers, because as you go through this, if you actually get to trial and you actually have a jury reading these things, they may not remember things that you may have taken the time to understand and study over the course of months, maybe a year. If it ever goes to trial, it's being condensed and fed to non-experts in the course of the longest trial I've had is 6 weeks, and the last one I did was 3 weeks. You're trying to feed some very technical information to lay people in a very short span of time. So things like what your definition may have been, that'll be lost on them. They'll see contributing costs here, they'll see contributing costs on the jury charge, and I think it means the same thing. So give your lawyer a tool so they can say, look, when you look at the charge, don't let this confuse you. This is what this investigator meant by contributing costs. And it's not the same as what the judge says of contributing costs. So definitions and technical jargon matter. Okay, as I was telling you, if you can break your report into two, it's good. Because subsequent remedial measures are not admissible, and if I have to produce it, gives me one more obstacle for what I'm saying. It's a subsequent remedial measure. They can have the analysis, they can have the fact-finding, the causative analysis, the recommendations about what to do going forward. That they should never see that, and they should never have that. It makes it easier because it's broken up into 2 documents. So you're allowed to do that. I kind of like that. All right. Now, let me talk to you a little bit about some evidentiary issues, and that's foundational facts and assumptions. When you do some kind of analysis, the courts developed a fairly defined method of evaluating whether an expert has done a good job and whether the jury should be allowed to hear it. And it turns on the foundational facts. Have you collected all the facts that are relevant to your incident? And based on those facts, have you made assumptions? And are those assumptions supportable? And then the last thing they look at is the methodology. Did you use the kind of methodology that is typical for your field? Do you have an error? Do you have a sense of what kind of error you might have? Have you taken steps to make sure you protected against that? Have you considered other causes, and have you eliminated them? Those things are things that courts are looking for. It's very, very straightforward. Do you have the right foundation, the right assumptions, and did you use the right methods? I'll give you an example from my case. In my case, when I say there was very poor work done, the theory in my case was that high ammonium bisulfite led to sulfide stress cracking, okay? And I asked the people, how do you know your data is any good? I said, well, the lab gave it to us, so it must be good. So I said, well, give me all the lab data. So I get all the lab data, I said, well, look at this, you got 337 ppm, and then 1 week later, on a unit that's processing 150,000 barrels a day, so you got these huge tanks that don't mix very often, you jump to 2,138. What did you do to confirm that's true, to believe it? And I just pick those randomly, I go and find them, and that's why I say, in this case, the laboratory analysis was no good. It shouldn't have been relied upon to come up with ammonium bisulfite concentrations. And here's the reason, because as you dig deeper into it, you find out that, well, they've got a machine, they don't care about these numbers for quality control. They use the same machine, but the way they get to it, well, these numbers are pretty big. Their machine is calibrated for 5 ppm. They're expecting 500 ppm, so they dilute by 100. And whether they get a good result or a bad result depends on the quality of their dilution. And nobody cares. So they never looked at these numbers in the 5 years that they ran the equipment, and then there's an accident, and all of a sudden they start believing them without evaluating. So when I say, those are the types of things that, as a lawyer, I look for. Are the assumptions good? Was there foundational reliability? The foundation of the opinion is, we've got a problem with ammonium bisulfite. It's running real high. And I look at it and I say, well, you've got a lot of peaks, and you got some peaks you can't believe. So I think you've got bad data, and I think if you're assuming that you've destroyed this piece of equipment because it was not sufficiently resistant at 8% ammonium bisulfite, you don't know you ever had that. Right? You don't know. Those are the things, and we get, as attorneys, we get to that level of detail. We get to looking for those levels of problems. The other thing, I'll give you another one just to give you an example of this is another thing I did is I went back through, air coolers have failed a lot. API has a whole recommended practice on air coolers. And what I did is I went and got all the API data I could find, and I plotted it based on pressure and concentration. And the assumption was that these concentrations of ammonium bisulfite were a problem. Well, the only recorded incidents were out there in the red. My guys that said my stuff was bad were running in the green. So that's another thing. You're making an assumption because nobody has a good handle on when you have failures in these air coolers and refineries based on pressure and ammonium bisulfite. You don't have a good handle. All you have is data by experience, right? And that's what a lot of the data in our industries are, right? Nobody's done some kind of study to see what pressures and what concentrations and what stresses you have sulfite stress cracking. It's not practical, right? It's not practical. So what you have is an experience-based set of standards. And the question then becomes, if you're going to make decisions and you're going to sue people based on experience, you ought to make sure you're fitting within the known data. In this case, I didn't think they were, right? Yet they thought my ammonium bisulfite was a problem. But the industry data doesn't support that.
Is a lot of the AI data collection and stuff changing some of the story, like maybe 20 years from now it might be a little different, because they'll have to wear it.
Yeah, that matters. Like in this case, they said, well, when we designed this equipment, this was a state of knowledge, and there were 3 separate editions of this recommended practice. And my argument is, if you're trying to lay blame, you need to use the most recent science. You could use the old standards to decide whether you made a good decision to put duplex stainless steel in, and you can use the evolving standards to see if you did a good job of trying to maintain it. But you can't use the old standards when you're trying to pin blame, when you're trying to pin causation, because you know it's like a pharmaceutical. I may think today it's great, and 10 years from now I say, well, shit, that caused cancer.
I guess that's where in 2019, when you're just inundated with data, the standard's going to change faster than your book that was dusty that you hadn't got off your shelf for 20 years may not be the right.
Exactly. That may be the right book. It might not be the right book. Yeah. Okay, so this is going to be the last slide, and then if there's any questions, I'll answer them if there's any additional ones. Here's some thoughts on corrective action, okay? It's got to be practical, and it's got to be achievable. And why is that? Because you might have another accident in the future, and that report that you made, it's going to be probably discovered. And if there are recommendations in there that were not approved, all right, that becomes an argument for liability. They knew this could be prevented with this particular change or this particular equipment or this particular procedure. They chose not to do it, all right? And in truth, what may be the case is there were better ways to do it, more economical, or you could do through, there's always a trade-off, right? You can make things very robust if you're willing to spend a lot of capital, or you can make things safe, but you may have to have a stream of expense in the form of preventative maintenance or monitoring, and that's a trade-off. So when you recommend corrective action, have that in mind. Have actions that have a realistic chance of being implemented and that the company can realistically accept. Things that are really not practical are not helpful. Right? You want to try to make sure they're implemented because, as I say, there's nothing worse than coming up with a potential corrective action putting it in paper, making a recommendation, and then seeing that it doesn't get done, then you have another accident under the same or similar circumstances. And the last thing is you really want to make sure you think about this before you actually commit it to paper. Because once it's on paper, it's tough to take back. Because typically, even drafts are discoverable if they're still around. And in this day of electronic data, you know, things can be brought back to life that you thought were gone. So those are my observations on accident investigation and analysis. Any additional questions?
Keep talking about documents being discovered. What makes a document undiscoverable as opposed to discoverable?
Privilege. And privilege means that it was prepared by or for an attorney, or it was prepared by the client at the direction of the attorney in the course of an investigation, anticipating litigation. You pretty much have to have a lawyer somehow involved. If you have it, right, and it's got to be, you've got to have counsel telling you, go interview these people. But here's the thing, once you interview people and you put it down, that's probably going to get discovered. But communications, direct communications, that's always shield. And it shields anyone who has interaction with the lawyer for the rendition of legal services. So not every communication is necessarily privileged with an attorney. If you and I are talking about a deal, that's probably not privileged, right? Because that's more normal course of business type stuff.
I'm thinking what you're describing here is sort of a typical case is probably a case in the United States. Is that
Yeah, that's typical of the United
so
States.
you talk about starting with using the root cause analysis.
Mhm.
Now, I wasn't an investigator, but we were on a project that was a number of years ago, maybe 18 or so years ago. There were some fatalities. But the operator didn't decide to actually conduct any kind of an investigation. It's going to happen. And really, we could just see from afar that all the really was used to sweep the whole thing under the rug.
Right, because there were no regulations or guiding there.
So it was, I'm just sort of thinking.
Yeah, it really depends on the jurisdiction, right? If it happened in the UK, there'd be an investigation, right? They might even have the health and safety executive in the middle of it.
So it seems like you're talking about when everybody's really being objective and playing fair about this rather than.
That is the assumption, right? That is the assumption that it's
Yes, quite, yeah.
yeah, if you're someplace else where you just don't have the interest or the regulatory incentives to really analyze and adopt corrective action, you know what I'm saying, really doesn't have a whole lot of application.
Suppose you have a piece of equipment that is warranted for 1 year after delivery, and the design calculations is based on rules of 2010, 2015, all design rules change. Do you think the operator now needs to go as liable if the failure happened at this equipment because the design rules and API codes, etc. have changed?
I think so, and I think there's the potential for that. I don't say that it would happen, but the argument is your duty, right? Your duty of care is based on what you know or should have known at the time. So if putting a piece of equipment that may have been considered fit for service 10 years ago is no longer considered fit for service because there's been a change in regulatory requirements, well, you're going to be judged by the state of knowledge when you make a decision that it was fit for service.
So you can't just say, hey, I didn't know that the rules have changed. You cannot.
The rule is knew or should have known, right? So if you're not staying on top of it, then you're saying, well, I shouldn't have known, and sometimes that's a tough argument.
Well, it's the user, yes. That's not the manufacturer.
That's the user.
Yeah.
Yeah. Usually, for the most part, the jurisdictions are different. If I'm a manufacturer and I sell you a product, once my warranty's expired,
Yeah.
I'm pretty much free.
Yeah.
Right, pretty much free.
I know for like flow lines and stuff where like, sorry, but yours sounds supposed to be top, like onshore stuff, but you have fit for service, campaigns and
Assessment.
assessment is the right word, yeah. So I think most of those are not governed by a governing body like SC or EMS, but it's it's put on the company to decide what's the right protocol for them. Is that right?
It often is, right, in API standards, and the thing is, sometimes you have API standards that are adopted within the regulations, API standards that aren't, and then you have API recommended practices, right? And you have an incident, then
And it might be kind of compared to how close to the edge you're operating that piece
right,
of equipment.
right, it becomes very subjective. It becomes, you know, there are things that are safe harbors, right? If you're complying with everything that's required, you might be okay, but if there are, and there's nothing else, right? There's this API standard, it's adopted by the regulations, you're meeting it, and there's nothing else out there, you might be okay. But maybe there's this API standard, but then there's this recommended practice over here that touches on that. You might not be in the safe harbor anymore, and it becomes just a question of the people who will judge you, the jury, about whether you acted reasonably.
I mean, in many respects, the entire offshore industry relies on grandfathering. The whole industry relies on grandfathering. All the jack-up rigs are grandfathered to the class rules. All the equipment's class relies on the API rules. They design it. The entire system is grandfathered. I mean, to say that it's all upgraded to the latest rules is absolute rubbish.
Well, I'm not saying
It's not even that close to that.
You know, and that's not what I'm thinking about. You're thinking about the design rules, right?
Yes.
Well, I'm thinking, I think, for example, I think the BOP rules changed, right?
Yes.
Those things have application going on a go-forward basis. Right?
Yes.
And those are the kinds of things that you would be judged by, right? If you have a grandfather rule where everybody accepts that this is adequate, that's one thing.
Yes, but the reason that the BOPs became the sort of people said, oh, you can't do that with BOPs, is because some bloody disaster occurred. If there's some disaster hadn't occurred, people would be saying, oh, we can still test the BOPs the way we did for the last 40 years. And it's a mockery to say that people are using the latest standards. They're not. They're not even assessing them to that, and they're not testing them to that. All the surveys are to the design standards, unless the surveys are required to be updated by the latest design standards.
And that's, I think we're saying the same thing. That being the standard you're judged by is what applies to your situation at the time. Maybe it's old,
Yeah.
but if the industry has been satisfied with that, no one's going to say they're really. In the case of a grandfather standard, is there? Because I don't know your industry, right? In terms of the technical engineering aspect. Ultimately, let me tell you how it really works in practice when you're in litigation. When you're in litigation, you have an accident, somebody gets hurt, they bring a lawsuit. And the argument is, you've been negligent. That negligence, really, the standards are just evidence of the standard of care. Ultimately, the court's instruction to the jury is measure their conduct by what a reasonable person in the same or similar circumstances would have done. Right? And ultimately, it becomes up to the jury to decide, because one side's going to say, these are the most recent standards. A reasonable person would have said, this equipment's decrepit. I need to have changed it. That's what a reasonable person would have said. Then years on this other side, my equipment's not decrepit, it's old, but heck, I got this 1957 standard that says it's fine. And it's up to the jury to decide whether you acted reasonably. That's ultimately how it really plays out.
And do some of those things probably play into what accidents have been happened on this since 1957 when the standard was written, and how many people, all of that accidents would have said, hey, you should have updated your equipment.
Yeah, it just depends.
Yes. Just as you said, how can a jury decide something that the government and the regulations say is acceptable? It's not up to the jury, it's up to the regulations of the government to say. You know, if you're speeding at 70 miles an hour and it's a 60 mile an hour sign, it's not a jury doesn't say, well, you know, it would have been good if you did it 50, you're guilty. It said 60, you did 60, that's fine.
In the same, let me give you an example of how things can happen. I didn't try this case, but a trucking case that happened in the winter, and the truck lost control on the road, skid across, and actually it's worse than that. The truck didn't skid across. It was the accident. The other vehicle, a passenger vehicle, lost control on an icy road in a storm. It skidded across and hit the truck. The truck, there was a judgment against the carrier for $90 million. The negligence on the part of the carrier, he wasn't speeding. The jury decided that that carrier should have known that it was unsafe to put a truck on the road under those circumstances, and it wouldn't have been there but for that decision to go forward. Because there's DOT rules that suggest, when you get to certain weather conditions, you gotta not be driving. Well, this guy didn't get off the road, right? He kept going. But he was on the edge. What's going to happen, who knows? That case is up on appeal. But all I'm saying is, whether you have complied with regulations is a different issue of whether you comply with the common law. Right? And liability is determined by the common law in the case of injuries. Right?
So, when I had a sire inspector come on board and say, your pump room, you should have a block and tackle to get people up on top of the bottom of the pump room. You failed your inspection, because you haven't done one. Show me in the regulation where it says I have to do a block and tackle. He said it's a really good idea, it's a great idea. But, I've complied. Thank you very much. And that's life, isn't it?
It is. But
I may go back and I may make the recommendation, I may fit blocks and tackles to all the vessels in the fleet. Right at that very moment, I'm saying, I'm complied with the regulations, thank you for your comment, but it is only a comment.
Well, that's right, and that's a different question, right? It's a different question whether you comply. Whether you comply with the contract, whether you comply with the regulations, is not often the same question about whether you're responsible for an accident. Right? Especially in the context of an injury case.
I'm sorry, I agree with you. I agree that there is a separation between the two. And I'm not trying to say that meeting all the codes and regulations necessarily means that you're safe. Or the other way around, you could be failing every single code and regulation and still actually be very safe.
That's exactly right.
But I think that there were some implications of what you said, that a company should always be following the latest set of standards. And it was your statement about that made me, really got me.
Yeah,
It's
so
not the
maybe I said it too strongly. All I'm saying is, as a matter of practice, when there's an accident and there's a question of who's responsible, the regulations are evidence of what is appropriate conduct, but they are not determinative.
Oh, yeah.
You're judged by what a reasonable person should have done based on the knowledge they had at the time. That's all I'm saying, right? It's not the same question.
So, just to finish up, you've talked about reasonable and you've talked about that, you've talked about demonstrating due diligence. And if I follow all the latest standards that I'm required to follow, why not demonstrate due diligence?
You have demonstrated due diligence. You have. You have. So the question is, then really, was there something else that you knew or should have known? If there isn't, then you're probably in pretty good shape, right? You've done what the industry, it always turns, not always, but often it turns on, this is the body of standards, this is the standard of care that the industry has. Often it's the APIs, right? Because they have so many publications. In the case of vessels, it might be the ASME, but those are looked at as what should have informed your conduct. That's what they're used for. They should inform. And if you have taken it into account, they've informed your conduct, and you acted reasonably, that's all that's required.
And that's what you said about, if you've had previous incidents that were similar and you didn't do anything, then you haven't demonstrated due diligence. Even if the regulations, you complied with them, if you had previous failures, you didn't.
Well, the regulations can't
Yeah.
can't give you information on everything. They can't give you information on everything. I'll give you an example. Let's say you've got a piece of equipment manufactured to an API specification. You brought it in, you comply with all the manufacturing codes. But the API doesn't tell you how to operate that piece of equipment in all circumstances, right? And if you operate it in certain regimes that weren't considered, the API is not going to protect you, right? That's all I'm saying. These things become really fact specific, and the standards and recommended practices simply are used as a way to judge whether the activity is
Can I ask you a question? If you say the collected the evidence during this incidents happen, if this is fatal or some very bad disaster and accidents, they destroyed most of the important evidence such as blaster or explosion, that maybe destroyed majority equipment, parts, whatever, helping conduct this investigation.
How do you mean? I'm not sure I understand.
I just say if the instance destroyed, except such as accident.
You might not have enough evidence to reach a good conclusion.
Yes.
Right, that can happen. Right.
So for this, okay, how can you blame whose fault, whose? Very difficult to.
It is difficult, but all I can tell you, as a practical matter, if an accident happens and somebody thinks someone else is responsible, they'll look for the evidence and they'll put forward the best case they can. Right?
Maybe sometimes leading in the wrong way.
Yeah, and maybe they win, maybe they lose. But when there's a significant incident and somebody genuinely feels that someone else is to blame, they're going to try to put together the best case they can, right? Especially if there's a lot of damage involved. And it always happens in my experience.
Yeah, I just think that is a comfortable case, basically on this kind of things happen.
Right.
Can liability be imposed retrospectively? If, for example, take your air cooler, if it turns out that the hazard probability study hazard was in some way not sufficiently rigorous, because you would obviously, that's one of the pieces of evidence you would look at, to see where the air cooler figured in the hazard.
Right.
I would have thought. But if it turns out that the hazard in some way was not particularly well rigorously conducted, does some liability extend back to the people?
I think it does, right? That was one of the pieces of evidence that I advanced in my case. The hazards review they did overlooked some very significant risks, and consequently they did not appreciate what they were doing. That was one of my theories, right? In the case was, you should have also talked to the people and understood why they said this hazard didn't exist. I thought there was a hazard of freezing that would lead to problems with maldistribution of hot fluids that overloaded a specific area of the airport, right? So that was a theory, right? And that's why I said there's a lot of money involved. And if you believe you owed it or you believe you don't owe it, you dig deep to see what really happened.
Can I take that idea another step? My question would a lawyer defending or attacking ever go to the actual standards and question them? Because all standards are written generally by committee who will have different opinions and they'll come to a compromise. The standard is always a compromise generally between the manufacturers and the users.
It's very hard. It's very hard. I'll just tell you my experiences. There's a lot of reluctance for standards committees to testify because the truth of the matter is that it's as you say, you try to bring the standards up without rendering somebody's plan obsolete, right? There's some give and take. And my sense is nobody wants to get on record about how that process works. But I think as a matter of practice, people get together, they're practical, and they say, let's push it up without absolutely rendering everything obsolete, because it's not cracking. Right, there's a balancing there, and you're right, in the ideal world, if I can show that enough people on a committee think otherwise, yeah, I'd like to do that. For this case, I went back and I got every draft of the relevant API standards and comments I could find, to see if I could find anything there that was helpful. Right? But getting members to testify, that's a different matter. There's a tremendous reluctance to do that.
Can you compel them to?
Pardon me?
Can you compel them?
You can try, right? but I'll tell you, if I've got a member I want to force, and they're in California, I've got to file something in a California court, and I've got to deal with a California lawyer that comes in and says, you're never going to talk to my guy. And then, I get an order from the court that says, yeah, you get to talk to my guy, and that guy doesn't like it. So now it's at the appellate court in California. There's a lot of ways to put an obstacle in front of that kind of stuff.
We have two more questions.
Okay, I ask you a question. The table was one showing that was the emission of this. So we say you have the number is some out of range and really bad. How do you interpret this?
My argument when I was in front of the jury is, don't believe it. It's not good data, throw it away. They can't prove their case. Right? That's the basic argument. It's garbage in, garbage out. Right? They assumed it was accurate when it wasn't.
The second, the table, it shows the green, that was the normal, and the pressure to 2005, the 2500, that was figure. Is that the actual data, or is just the manufacturer?
No, that was actual data that what I did for that particular thing in this case is I pulled all of the API standards, and they had reported incidents with estimated concentrations, estimated pressures, and sometimes they had incidents and sometimes they didn't. So what I did is I found every published article that I could find on air coolers, pressure, and ammonium bisulfite concentration, and then I applied it. Because it's all based on experience, and I said, you're outside, you're well within the levels of accepted experience. And that was my argument. You can't say my cooler was susceptible to ammonium bisulfite cracking because I was operating in a regime where the industry experience tells me it's safe. You don't have a data point anywhere that says this should have happened because of ammonium bisulfite. That's all I did, right? Because when you look at those standards, they're based on experience, right? There were some studies on corrosion, but not cracking. Corrosion is not cracking, right? Different mechanism.